In the meantime, the Court of Appeal Abuja Division has ordered that Rivers State government should not give effect to the judgment which cleared it to collect value-added tax for the state. A three-man panel held that parties who have submitted themselves before the court should maintain status quo pending the determination of the application to stay of execution of the lower judgment filed by FIRS and the application by Joinder of Lagos State. TVC News Judiciary Correspondent Celestina Area reports.
Rivers State has been on the front burner in championing the cause to stop the Federal Inland Revenue Service from collecting value-added tax from states and remitting same in the coffers of the federal government. Governor Nyesom Wike has expressed misgivings at the level of which the state is treated unfairly, as the state generated about 15 billion naira as VAT in June 2021, but received only 4.7 billion naira. Lagos State generated over 46 billion naira as VAT in June, but got just over 9 billion naira, whereas Kano State generated 2.8 billion naira and also got 2.8 billion naira as allocation. VAT is a consumption tax paid when goods are purchased and services are rendered. It is charged at a rate of 7.5%. Concerns have been raised as to why some states benefit from VAT raised by other states. A case in point made by well-meaning Nigerians is the sale of alcohol drinks in some parts of the country, while it is prohibited in other parts. Yet, all states benefit from the VAT made from the beverages, since the monies are remitted into the coffers of the federal government. In a bid to get a clear constitutional interpretation of this, the Rivers State government filed a suit against the Federal Inland Revenue Service. On 10th August, the Federal High Court sitting in Port Harcourt, Rivers State, declared that it is the Rivers State government and not the Federal Inland Revenue Service that should collect value-added tax and personal income tax in the state. Presiding Judge, Justice Stephen Palm, also issued an order of perpetual injunction restraining the FIRS and Attorney General of the Federation, both the first and second defendants in the suit, from collecting and intimidating residents of Rivers State to pay to the FIRS personal income tax and value-added tax. The State House of Assembly in Rivers State, in line with the judgment of the court, passed the bill for collection of VAT, and same was assented to by Governor Nyesom Wike. On the 9th of September, the Lagos State government told the Park of Rivers State as a bill to empower it to collect VAT was passed to the State House of Assembly, and a copy was transmitted to the governor for assent. Dissatisfied with the judgment of the lower court, the FIRS appealed the judgment of the court. The FIRS, in its appeal, is seeking a stay of execution of the judgment delivered by the lower court and an interlocutory injunction. At the hearing, the Lagos State government filed an application for Joinder in the appeal. The Attorney General of Lagos State told the court that it is in the interest of justice that Lagos State is made a party in the suit, as the state is on the verge of executing the judgment. In its ruling, the Court of Appeal suspending the collection of VAT by Rivers State's government and other parties to maintain status quo ante bellum, which is the position before the judgment of the lower courts was delivered.
Injunction application is still pending, but we are excited that the court have decided in its wisdom to preserve the rest, so that it doesn't force a situation of complete hopelessness on the part of the court. At least it will stabilize the economy, to stabilize the nation.
All parties who have brought themselves before the appellate court should not give effect to the judgment delivered by the lower court, pending the determination of the application to stay execution of the lower court judgment, an application by Joinder of Lagos State.
Our application has not been heard. Should the court allow Rivers State to start collecting tax, even though we are telling this court to say, hold on, until we are heard? So the court is now saying, well, we have not heard them. Until we hear them, no decision can be taken one way or other. But everybody should hands off. Hold on. Don't effect the judgment of the Federal High Court until after we have heard them. If we agree with them, fine. If we don't agree with them, then you can go ahead.
The court also ordered Lagos State to file and serve their processes in the application of Joinder to parties. Celestina Area, TVC News, Abuja.